Kenny 911, what is the address to your emergency?
Yeah, on
Hello, everybody. Hello, Lou, John, Rammer, keeping the swine in line. 2A Dave, John Denicola, I think I already mentioned that, and everyone else watching the stream either soon or after the fact. Hello and welcome. I tried to do this in our Open Carry Texas group on Facebook Live, but the screen sharing issue was just infuriating. So I'm going to do it here, and then I'll just share this link into our Facebook group of Open Carry Texas. But I've been seeing a lot of, there was a question that we had there that it was from a person who is in the process of applying for a license to carry a handgun in Texas. As you know, a license to carry a handgun is not required in the state, but it does have some benefits. And so the question that she had, or he, I can't remember, was whether or not the 30.6 or 30.7 signs at businesses applied. And the correct answer is no, they do not. If you do not have a license, the 30.6 and 30.7, that's the 30.06, 30.07 signs, do not apply to you, okay? If you do have a license, they do apply to you, the 30.6 and 30.7 signs, and the 30.5 signs do not apply to you. Now, what does that mean? If you see a 30.06 concealed carry prohibited sign and it's got the correct language, then you can't carry into there concealed. If you see the 30.07 open carry prohibited sign and you have a license, and same with the 6, you're not supposed to carry into that private business openly. A business can have one, or they can have both, or neither. If they only have a 30.7 and they don't have a 30.6, that means they just don't want you to open carry in there, but feel free to come in with your concealed carry. If they have a 30.6 but not a 30.7, then they're saying, we don't want you to conceal carry your gun. We want to know that you have it. And so go ahead and open carry, but don't conceal carry. If they have a 30.5 sign, it means that we just don't want any unlicensed people to carry their guns in here. And I'm sure the criminals are really listening to that one. I guarantee it. In order for them to completely ban guns, a business should have a 30.5, 30.6, and 30.7. Now, I say should have because they don't have to put up any signs at all. If you walk in there and you're either concealed carrying or open carrying, and they know that somehow that you've got a gun, either through sight or maybe a bulge or something, they can come up and ask you, are you carrying a firearm? And of course you can or cannot answer. You can say yes or no, it's up to you. But if you tell them you have a firearm and they say, well, we don't allow guns in here, that is proper notice, whether they have signs up or not. So don't argue with them. Once they say we don't allow guns in here, then all you got to do is just a simple follow-up question. Well, would you like me to leave with my gun? And, sometimes they'll say, well, we don't allow it, but I mean, you seem like a nice guy. Don't worry about it. Just kind of try to keep it hidden, or they'll say, yes, I'd like you to leave with your gun. And then you have to leave. If you don't leave, it's a criminal offense. However, where it really gets tricky is this 30.5. And I want to share something. And before I do, I want to say that I have nothing but utmost respect for almost everybody at the firm of Walker and Taylor. There's only one individual there that I think is a snake in the grass. But other than that, Edwin Walker and the other attorneys at this firm are great. But there's something that I wholly disagree with, and people keep sharing this link, and so I kind of want to address it for Open Carry Texas because I don't believe this is accurate. That doesn't mean that I'm right and they're wrong, and it doesn't mean that they're right and I'm wrong. It means that there's a difference of opinion, but I believe based off the law I'm going to show you that my opinion is accurate here. And the way that they've written it, I mean, we can both be right. We can both be right, but I just don't want people to think that it's cut and dry. And so I'm going to share this with you. This is the firm of Walker and Taylor. They are the Texas Law Shield, I believe, attorneys, contract attorneys. They do a lot of 2A law as well. I've worked with them in the legislature. We've testified on bills together. So again, I don't want this to be a critique of them. And the only reason I'm bringing this up is not to go after fellow attorneys, but because this exact link keeps being brought up in the discussion on 30-5 signs. And so I wanted to address at least the link here. Now in here, he's got a great discussion here of what the 30-5 sign is supposed to look like. And this is similar to what it should look like. Okay. If you see a 30-5 sign, it must look like, it doesn't have to have the little gun and the crosshairs in it. It can just have the language here, but it's got to be in English and Spanish. And, it's got to conform to certain, contrasting colors, 1 inch high, all that kind of stuff. Okay. This is I would argue, a proper sign for unlicensed carriers. So as I mentioned in the beginning, if you don't have a license and you're not sure if you can carry into a building, this is the sign you want to look for. Okay. It may or may not have this gun buster sign. This is not required. Okay. It may or may not have that, but you have to see this language in English and Spanish, and it's got to be in contrasting colors. It's pretty much got to be obvious. All right. It can't be hidden. It can't be blocked. It can't be in colors that cause it to blend in with the background. It's got to be in contrasting colors, just like you can see here. If they had a black background and gray letters, that would not work. So, but then a little bit later, he talks about, or they talk about, whoever wrote this, talks about the gunbuster sign. And this is where I somewhat diverge. He says the no gun sign, commonly called gunbusters. Previously, this image alone did not carry any force of law. I argue it still does not. However, we have to remember the broad sweeping language of 30-5. These likely, now this is a big word here, okay? So he's not saying definitively that this particular sign alone is legal notice, okay? But he's saying it's likely that they have the same effect. And the problem I have is with this kind of being in bold, this is what people see. They don't really pay much attention to this likely word here. And I actually disagree. I think these likely do not have the same effect as the 30-5 sign. Simply put, this sign may preclude someone from carrying under the Firearm Carry Act of 2021. That's, of course, HB 1927, from carrying on the premises, but would have no effect on handgun license permit holders. Okay, so that's it. This is the part that people keep talking about, and I really want to clarify this. Okay, and I'm doing this with respect to Edward Walker's firm here, because these are great guys. Okay, great guys. So I'm not criticizing what they're doing. I just disagree with this. All right. And you know what? You look at any case, go into any courtroom, and you're going to see two attorneys at different tables arguing different interpretations of the same law. So that doesn't mean I'm right. It doesn't mean that they're right. It doesn't mean that either of us are wrong. I'm just going to explain why I think I'm more right. If we go over here and, and before I get to 30-5, let me clarify something here about 30-6 and 7, because there's also a discussion about, okay, well, if I'm not carrying my license on me, then I'm carrying under 30-5. Wrong. Because a license holder this word license holder doesn't mean that you're physically holding the license. It means that you are licensed under Chapter 411 of the Government Code. Okay? That's what this means. It doesn't mean that it's physically in your possession. If you are licensed, if you carry a concealed handgun under the authority of subchapter H 411, you fall under 30-6, whether or not you carry that license on you or not. It does not matter. Once you get a license, 30-6 and 7 signs apply to you. You can't. I mean, look, if you're not carrying your license and you come to me and you've got a 30-6 violation. I mean, obviously I know what arguments I could make. I mean, we could always argue that this means I have to be holding my license, right? or I have to be carrying my concealed handgun under the authority of subchapter H. But maybe that day I'm carrying my handgun under the authority of 30.5, right? And that's why I didn't bring my license today, because I don't want to be hampered by 30.6 and 7. All right. So I just wanted to make that clear, because whether I believe, and there's an argument, I think any good defense attorney will make an argument on either side, okay? But I'm telling you to stay out of trouble. If you have a license, 30.6 and 7 apply to you, whether or not you're carrying that license on you or not. Sometimes I don't carry my license on me because I don't carry any identification on me based on what I'm doing, because I don't want to be force identified or forced to identify. All right, so let's go back up here to 30.5. 30.5 is it used to be just a generic criminal trespass statute. It had nothing to do with guns. But what happened was, when HB 1927 was addressed, they had a choice, which I think was stupid. We argued against this because it's incredibly confusing. We're already seeing how confusing this is. And our thought process was, look, why make an entirely new sign? Why not just make the 30.6 and 30.7 apply across the board to open or concealed carry? Okay, it's either banned or not banned. Now you've got to do this whole thing about, okay, open, concealed, now unlicensed. All right. Here's what is required, and this is why I disagree somewhat with what was stated on Mr. Walker's website. Okay, because when you go down here, here's what was added to the statute. Did I pass it already? Might have passed it already. Okay, where did it go? I think I just passed it. Yes, I did pass it. What the heck? I just had this sucker. Okay, here we go. It's right up here. There we go. All right. So subsection C, a person, this is what was added here. A person may provide notice that firearms are prohibited on the property by posting a sign at each entrance to the property that, remember, includes language. Okay, if you look, this doesn't include any language. This is just a sign. So right off the bat, I think C1, just the first two words there, negate the gunbuster sign, because it has to have some language. There's no language here whatsoever. It's just a big red circle and a pistol. Now you can say that, well, that's descriptive language, possibly, just like an emoji. But if you go further, it's got to be language that is identical to or substantially similar to the following. And this is what it's got to say. The gunbuster sign, if they're using this gunbuster sign, it must be accompanied with, pursuant to section 30.5 Penal Code, criminal trespass, a person may not enter this property with a firearm. And it's got to be in both Spanish and English. It's got to be in contrasting colors with block letters and at least 1 inch in height. This has none of that. There's no contrasting colors. There's no 1 inch height. There's no block text. Nothing. And it's got to be displayed in a conspicuous manner, clearly visible to the public. So this is the section that applies to the signs right here. And it's very, very, very clear. So that is why I would disagree and tend to disagree with this idea that these signs are likely to have the same effect. I don't think that there's any broad speaking language in 30.5. I think this is very clear. There's nothing broad about it. It says that they can provide notice that firearms are prohibited by posting a sign that includes language. And that language has to be identical or similar, substantially similar. And by substantially similar, instead of pursuant, it could be in accordance with section 30.5 or according to section 30.5 or under section 30.5. That's substantially similar to this. Okay. A person, you know, they could also probably say a Texan, but this is a person because it doesn't matter if you're a Texan or not. It could say a citizen because that's pretty substantially similar. Although if you say a citizen, then that means illegals can carry in there because they're not citizens of this country with a firearm. Okay. So it's got to be language. It's got to include that language in English and Spanish. If you don't have English and Spanish, how can this have the same effect? Because this is neither English nor Spanish right here. It's not German. It's not, I mean, you could say that's the universal language, but it's required to be in English and Spanish. And keep in mind, nowhere in here in section C does it say anything about a gun buster sign. It literally talks about, in order to prohibit firearms on the property, you have to have this 30-5 thing here. Okay. Now, I also want to tell you what is broad about this. What is broad about this is that a person may provide notice that firearms are prohibited on the property. Notice it doesn't say licensed or unlicensed. It says a person may provide notice that essentially you can put in here all firearms are prohibited on the property by posting a sign at each entrance to the property. So if you see a 30-5 sign, it doesn't matter if you've got a license or not. Under this language, they don't want any guns. This is your gun buster sign, is the 30-5 sign. Because this doesn't just apply to unlicensed carry. It applies to unlicensed carry, licensed carry, criminal carry. It doesn't matter. As long as it meets these other criteria. So, just so you know. Now, I see some comments about any laws contrary to the Constitution are invalid. Well, the Constitution applies to government, not private property, and that's what we're talking about here. On my private property, I can require that in order for you to come onto my private property, you can't weigh more than how much do I weigh? Okay, so you can't weigh more than 200 pounds. I can say that you can't come on my property unless you're neatly groomed. I can say you can't come on my property unless you're a libertarian, because it's private property. Those are our rights enshrined in the Constitution as well. And one right can't undermine another right. And since you have a choice on whether or not you go on private property, me using my property rights to say, that I do or do not support your right to carry, I'm allowed to do that because I'm not taking away your right. You don't have a right to be on my property. Excuse me. You don't have a right to be on my property. And if I allow you on my property, then you've got to meet my rules. Now, do I agree with signage? No, I think it's stupid. Nobody listens to this stuff that is intent on committing a crime or hurting somebody. The only people that care about this stuff are law-abiding citizens. So really, you're only affecting law-abiding citizens. You're disarming the very people that could help in an instance in which somebody is creating a problem. But I wanted to make very clear, 30-5 signage says that firearms are prohibited. Licensed, unlicensed, long arm, pistol, Derringer, shotgun, it doesn't matter. So, and I do agree that private businesses should be held accountable if someone's injured on their property, especially if they disarm them. Absolutely. I made that. I completely agree with that. So anyway, that's what the 30-5 sign is. It's essentially the gun buster. If you see the 30-5 sign, I'm going to use, because again, they've got a lot of good information on here. Edwin Walker and his folks, for the most part, with only one exception I'm aware of, are great pro-gun people. All right. This is what you're looking for. If you see this sign, it doesn't matter if you're licensed or not. If you see this sign with or without the gun buster, this is not required. Okay, this gun buster sign is not required. So if you only see this language, doesn't matter if you're licensed or not, on this private property, you cannot carry this firearm. Now, I will tell you, this does not apply to government buildings. Okay. If a place is not listed in Penal Code 46.03 as a prohibited place for you to carry a firearm, these signs mean nothing to you. Because if it's not a prohibited place, they're not allowed to post these signs on public property. The only real way that they're able to, and I think I did a video about this before, so I'm not going to really go into that, but I just want you to know, this is just private property that I'm talking about. This is what you're looking for. If you only see the gun buster without this language, it means nothing. It means nothing. Okay. So for those that are sharing this link, I just respectfully disagree with this particular part where they talk about this gun buster and that the sign alone may prohibit carry. I don't see it. It doesn't, it's not in the letter of the law. The letter of the law is very clear that it's got to have English and Spanish, these words. Okay. Let me go up here and see if there were any other, yes, they did create another sign. Let me see if there were any other questions here. Town Dex, the other form says you can open carry on a college campus as long as you leave your license at home. No, that is false. The other form, I don't know what that means, but you have to have, now you have to have a license to conceal carry on a college campus, okay? And you can only conceal carry on a college campus. So this idea of that you can, if you, as long as you leave your light, here's the comment. The other form says you can open carry on a college campus. No, you cannot open carry on a college campus no matter what. Whether you leave your license at home, whether you have your license on you, blah, blah, blah. You cannot do that, okay? Do not open carry on a college campus. You will get arrested. You will get prosecuted. You will likely be convicted. The law about that is very clear. All right, here's one. Can I carry in a city park? There are park rules in our local park that says firearms prohibited. All right, the answer is yes and no. Under 229 local government code 229.001, a municipality does have the ability to restrict firearms other than handguns in a city park. So if you see a no guns in the city park, it's only applying to, because the law has given the municipality the authority to ban like long arms, okay? But they cannot ban handguns open or concealed, licensed or unlicensed. They cannot do that. And that's 411.209. As a matter of fact, I will bring that up for you so you can see that as well. Oh, here, let me do this. Let me do this. I will share my screen again. Allow. There we go. So if we go to local government code 229.001, that is what tells cities. So notwithstanding any other law, this is the section here that deals with city parks. A municipality may not adopt or enforce regulations that relate to guns. Let's just say that, because this pretty much covers everything: transfer, possession, wearing, carrying, ownership, storage, transportation, licensing, or registration of firearms, air guns, knives, ammunition, or firearms, or air gun supplies or accessories. Okay. They can't do that. They can't regulate any of that stuff. However, that subsection does not affect a municipality to, and then you go down to 5, regulate the carrying of an air gun or firearm other than a handgun. So they're allowed to regulate the carrying of an air gun or firearm except handguns, as long as that person is allowed to carry a handgun. So they can put up, and this is stupid, I don't understand it, but they can put up a sign that says, hey, no criminal carry in this park, even handguns. If you're not, if you're a prohibited person, you can't carry a handgun, you're don't come in this park. But that's in a public park. So this is what you were talking about. This specifically addresses that question. The park rules of what they prohibit only regulate the carrying of a gun other than a handgun. So you may carry past into a public park regardless of those rules, because they're not allowed to create rules about handguns, as long as the person that they're trying to regulate is not otherwise prohibited by law to carry the handgun. Okay. And the same goes for a public meeting or municipality. And this is where I believe CJ Grisham's opinion here, that there's a little bit of a weird status in the law right now, because right here, this allows the government to regulate the carrying of an air gun other than a handgun at a public meeting or a municipality, right? Or a public meeting, but, and it might be under 4603, but it might be here as well. Let me go back and find this. Subchapter B. There's some weird, okay, I think it's under 4603. Let's go back to penal code. Penal code 4603. We bring this up. Now, if you look, commits an offense. Where is it? Blah, blah, blah. Here it is. In the room or rooms where a meeting of a government entity is held, if the meeting is an open meeting and if the entity provided notice as required by that chapter. Here's the problem. This says that it's illegal on one hand, that you're committing an offense if you intentionally, knowingly, or recklessly possess or go about or goes with a firearm or prohibited weapon listed in blah, 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 in the room or rooms where a meeting of a government entity is held, if the meeting is an open meeting, subject chapter 51, and if the entity provided notice. So if they put up a sign, right? But local government code says, well, they can't do that. They can't put up a sign, because it says right here in subsection B that subsection A, which says, hey, cities, you're not allowed to violate the, people's rights as it relates to firearms, all these things. Carrying is one, right? Wearing, carrying, possession. But that does not apply to a municipality under another law to, and it does say under another law. So you would think that that's 4603, right? As long as it's other than a handgun. So there's kind of a, the law says two things here. On one hand, it says, hey, you can keep rifles out of there, but you can't keep a handgun carried by a person otherwise prohibited by law. And then you go back here to chapter 46, where it says you're committing an offense if you carry into an open meeting in which they've published notice or provided notice as required by that chapter. So, and when it says notice, I'm sorry, actually, let me back up here. This does not mean 30.6 or 30.5 notice. Okay, I got a little ahead of myself. This does not mean 30.5 and 30.6 notice. This means notice of an open meeting, as municipalities are required to do. Municipalities are required to provide notice of an open meeting, saying, okay, we're going to have an open meeting on this date. That's how you know when your city council meetings are. That's how you know when your county commissioner meetings are, et cetera, et cetera. Okay, that's what this notice is talking about. It's talking about the notice required under Chapter 551, which is the Open Meetings Act. That's the notice that's got to be required, not 30.6 or 30.7. So on one hand, now if you go down here, so subsection 14, right? It gets even more confusing, folks. And I'm sorry, this is the law they created. If you go down here, there's an exception. Here it is. Where's chapter here? No, that's 1 through 4. Nope, that's a campus. Where is the Section 14 exemption? I probably could have had this up there earlier. Section 14. No, that's 13. A1. I'm going to get, I guess they got rid of it. Well, see, they even got rid of it. All right, it's in here somewhere. A13, no, it's A14. I'm looking for A14. All right, wherever it is. So that's the problem that we have. The problem that we have is, on one hand, this is saying it's an offense to carry in there, and I'm telling you, I am missing it. I've got to be missing it, because there's a part here that says they have to provide notice under 30.5 or 30.6. Did they get rid of that this last session? Did they sneak something in that we didn't notice? Because now it would appear they don't have to do notice. It's just a blanket open meeting ban. I probably should have looked at this a little closer, because I don't remember testifying on some bill that made it harder. Let's see. Okay, here we go. 1760. So this is 1927. This was the Unlicensed Carry Act. Let's see what this is. What did this do? Oh, this is where they okay, I remember testifying for this. This is how they clarified what a school was. So that, when did they change? All right, let's look at this here real quick. Let me get down to 4603. Here, let's just do it. Let's do it the fast way, shall we? 46.03. What? 46. Why is this not working? 46.03. That's not it. We need to go down to the next 4603, 4603, 4603. All right, come on. That's 42. Come on, almost there. Almost there. 30.6. Okay, 4602. All right, folks, this is gotten, yeah, I don't remember this being in 1927 here. Here's 4615, so it should be right up here. Okay, this was all added. $46.03. Now where's 14 at? We're going to have to fix that, because I think they've created somehow, they removed a section, because it used to be at the very bottom under 4603. It used to say that it was either an exception or a defense under 4. So here it was. It should have been in 4615. There used to be a section under 4615 that was an exception. And it almost looks like they got rid of it. This section does 4603A. Yeah, that's 8. Doesn't apply. 7, 11, and 13. Wow. All right, guys. I'm going to have to do some more research here off topic, or on this completely different topic, because this talks about A13, but I still don't see A14 in here. I think they got rid of somehow, but it's not in here. I mean, it looks like they added a 14, but 14 was already in there. So I think they got rid of the prohibition or the defense at an open meeting act. All right, that's for another. I'm not going to give any advice on that issue because on the open meeting stuff, all I know is, all right, the plain reading of this statute, folks. I'm just going to give you the plain reading of this statute. 4603, places weapons prohibited. A person commits an offense if the person intentionally, knowingly, or recklessly possesses or goes with a firearm, location restricted knife, club, or prohibited weapon listed in section 4605A. That's where all the prohibited weapons are. Then you go down to 14. In the room or rooms where a meeting of a government entity is held, if the meeting is an open meeting subject to Chapter 51 and provided notice. So if it's an open meeting, but they didn't provide notice that they were going to have an open meeting, then that doesn't apply. But there's no more exception down here that says that a person is licensed. So on one hand, it's an offense for you to carry into an open meeting. And on the other hand, they're not allowed to regulate. I guess it does say, okay, never mind. Oh yeah, they're not allowed to regulate handguns at public meetings. So it's an offense and it's not an offense. Yeah, we're gonna have to get that fixed. That's contradictory there. But what's important is the question about the parks is not contradictory. I think I just found an area of law where, because they didn't make it simple, constitutional carry like we wanted, they created laws that conflict with each other. And now there's confusion even by attorneys about this public meeting thing and what it means. If I can't figure it out, then obviously I don't see how a prosecutor could figure it out and charge somebody, but they don't care. All right. Oh, goodness. Let's go back up here. Please address the fact that a private business is still private property, even though it is open to the public. Yes, I have addressed that. Oh, hey, my client is here. Let me go ahead and close this out. I've got a meeting. I didn't realize that it was already past 10:45, but I discussed kind of what I wanted to discuss here, and I appreciate everybody. You guys take care, be safe, and be free.